This courtroom session starts like a routine hearing, but within minutes, it turns into a non-stop collision between sovereign citizen-style arguments, self-representation chaos, and judges trying very hard not to lose their patience on the record. First up is Gregory Smith, a defendant representing himself while throwing out constitutional citations, jurisdictional challenges, claims about unlawful procedure, and even demanding damages over property allegedly taken during his arrest. But here's the twist. Despite sounding extremely confident, the judge calmly dismantles almost every argument point by point without raising her voice once. And if you think that's wild, just wait until the second half of this hearing, because another defendant walks into court claiming he's appearing under special appearance, refuses to identify himself properly, challenges subject matter jurisdiction, and starts using phrases like overstand instead of understand. What makes this hearing fascinating is that these defendants clearly believe they've discovered loopholes in the legal system. But the judges have heard these arguments before, a lot before. And throughout this video, you'll see the exact moment where courtroom procedure crashes headfirst into pseudo-legal theories. You'll also notice something else. The judges aren't immediately exploding or throwing people in contempt. Instead, they're carefully trying to keep control while making a clean record for appeal purposes. That's incredibly important legally, because even when defendants are disruptive or argumentative, judges still have to protect due process. Now pay close attention to how each judge handles these situations differently. One judge responds with calm procedural explanations, another uses sarcasm and humor, and another becomes increasingly direct once the interruptions start piling up. The real question is this: are these defendants genuinely confused about the law? Or do they believe they can outmaneuver the court system by using sovereign citizen tactics? Let me know in the comments as we get into one of the strangest courtroom sequences you'll see all week.
The list of attorneys who accept advisory appointments is, it comes through the kind of the Office of the Public Defender. And there aren't as many attorneys as there used to be who are willing to accept advisory appointments. I do have an attorney who has been willing to accept appointments before. However, I also know that in the next few days, he will find out if he's been appointed as a county court judge. But I'm going to appoint him at this point in time. And then at your next court date, we will give you information as to whether or not he remains your attorney or whether we find out who that advisory council is going to be. Okay?
Sounds good.
Okay.
I'm
sorry.
Go ahead.
I just want to go on the record real quick.
Okay.
Okay, so I am Gregory C. Smith, Jr., appearing sui juris under the mandate of Article 6 of the United States Constitution, pursuant to UCC 1-308 and Colorado Revised Statute subsection 4-1-308. I reserve all my rights under the United States Constitution, including the 8th and 14th Amendments, Colorado Constitution, Article 2, subsection 7 and subsection 20, the United States Code, and Colorado Revised Statutes 18-1-504 and subsection 18-6-800.3. I acknowledge the appointment of advisory counsel to assist only in procedural research and technical filing. I remain the lead inquisitor and authorized representative. This appearance is restricted to challenging jurisdiction and procedural defaults and does not constitute a general appearance or consent to the court's jurisdiction of my private person. And I'm here to address the following, which would be the sufficiency of probable cause, specifically regarding the knowing element, the domestic violence designation, Rule 41E, property concerns, bond and protection order conditions. Because this is a felony trespass charge, I assert my right to a preliminary hearing under Colorado law. The charged offense requires a knowing unlawful entry under CRS 18-4-502. The state's own evidence.
What just happened here is actually a perfect example of why self-representation can become incredibly risky in felony cases. Gregory Smith clearly came prepared with statutes, constitutional amendments, procedural arguments, and a long list of objections. On the surface, it sounds impressive because he's citing real legal concepts: probable cause, unlawful entry, due process, preliminary hearings, and bond conditions. But here's the problem. Knowing legal terminology is not the same thing as making legally persuasive arguments. The judge immediately separates factual disputes from procedural issues and explains that many of Smith's arguments are matters for trial, not automatic dismissal. And notice something important here. The judge never says Smith is forbidden from making these claims. Instead, she explains why they don't eliminate probable cause at this stage of the case. That distinction matters. Courts don't decide guilt during early hearings. They decide whether enough evidence exists to continue forward. Smith is arguing innocence, but the court is focused on whether the prosecution has enough to proceed to trial. Also, the domestic violence designation issue is more complicated than many people realize. The judge points out that domestic violence classifications can involve coercion, intimidation, or control, not just physical injuries. That's something viewers often misunderstand when they hear no violence occurred. And now the pressure shifts back onto Smith, because representing yourself may sound empowering until you realize you're personally responsible for navigating felony procedure, evidence rules, objections, and jury strategy. Would you ever risk defending yourself in a felony case, or would you want a lawyer handling everything? Because this hearing is already showing exactly why courts strongly warn defendants against going pro se.
I move to strike the domestic violence designation per CRS 18-6-800.3. This designation is factually unsupported as there was no physical harm, injury, or verbal threat. Regarding the property, I move for an order under Colorado Criminal Procedure Rule 41E, wherein the officers conducted a warrantless transfer of my property to a non-owner and restrained party without providing an inventory or receipt, violating due process. I request a full accounting and the immediate restoration of my belongings. If such an accounting cannot be provided, I move for damages in the amount of $5,000. Finally, since the court previously found no forced entry and the VPO has been dismissed, the basis for the current bond and the trespass charge is void. I request the immediate conversion to a PR bond and release of my funds. And based on those factors, I respectfully request dismissal for lack of probable cause.
Okay. Let's start first things first. Given the nature of the charge, which is a Class 6 felony, and you are out of custody, you are no longer entitled to a preliminary hearing. A lot of what you have addressed is factually based, that would be determined most likely by a jury at the end, if we get to that point, setting the matter for trial and having a jury determine whether or not the alleged facts were done as an act of domestic violence, which, just for the record, goes beyond just an actual act of violence, but include acts done as methods of coercion, control, or retaliation. And so whether or not the domestic violence tag applies would be determined by a jury if in fact this matter is taken to trial, with a specific interrogatory being asked of the jury to find that the prosecution has proven beyond a reasonable doubt that any act constitutes a act of domestic violence. As to the factual basis, as to whether or not you believe the charges support the allegations that have been filed against you, again, you are not entitled to a preliminary hearing. A judicial officer has already made a determination that there is probable cause to.
This next section introduces a completely different courtroom dynamic, and honestly, it escalates fast. Unlike Gregory Smith, who at least attempted structured legal arguments, Prince Pew immediately runs into a major procedural problem: hybrid representation. That's when a defendant has an attorney, but also tries filing motions and arguments independently. Most courts absolutely hate this because it creates confusion about who is actually responsible for the defense strategy, and the judge here shuts it down immediately. What's interesting is that the judge isn't saying Prince Pew can never represent himself. He's saying there's a process. If you want to waive counsel and proceed pro se, courts usually require a formal request and a hearing to make sure you understand the risks. But filing random pleadings while still represented by counsel? That's not how the system works. And once again, we're seeing a pattern common in sovereign citizen-style cases: the belief that simply declaring special status somehow overrides courtroom procedure. pay attention to how the judge handles objections too. He doesn't debate the theories for long, he simply notes the objection and keeps moving. That's a deliberate strategy. Judges know that extended arguments over special appearances or alternative citizenship claims often derail proceedings completely. So instead of feeding into it, the court narrows everything back to procedure. But the really unforgettable moment is still coming. Because the next defendant takes these arguments even further and turns the hearing into one of the most awkward identity exchanges you'll ever hear in open
Matter
court.
Procedurally, noting that if you take the matter to trial, you would have advisory counsel with you. But again, as you are aware, they would just be advising you procedurally how to go forward. You would be the individual who is actually conducting the trial. So we'll give you a new court date here in a moment.
And you said the preliminary hearing was, I couldn't have one.
You're not entitled.
Not entitled to one because of what now?
Because of the element of the charge and because, or I should say the level of the charge, and you have bonded out. If you remain in custody, you are always entitled to a preliminary hearing. It changes a little bit once you have posted bond. But I'm going to give you a new court date here. And we're going to set that about 4 weeks out. And if you just want to spend a few moments speaking with Mr. Libby, unless you already know how to get your discovery.
Prince Pew, state would you please start a record? Yes, Your Honor, thank you. This is State of Indiana versus Prince Pew. The cause number is 64D012305, ISO F54448. Defendant is present in court in person by video conferencing, is here with counsel, Mr. Steve Provost, State of Indiana by Gary Gurman.
I think it's an F6 though. That's just a typo. It's definitely 2305 F64448. Morning, Mr. Pugh. Can you hear us okay?
Yes.
Okay, thank you. Mr. Provost?
Your Honor, I don't have anything new to report to the court. I haven't been able to see Mr. Pew since he was rearrested on this matter. However, I have reviewed the pleadings that Mr. Pew has filed, and I guess I'm looking to get some clarification from the court and Mr. Pew as to my office's involvement in this matter, Your Honor. From what I've read, it appears Mr. Pew is desirous of representing himself in this matter and has filed his own pleadings in accordance with that desire. But I want to be clear if in fact that is what he wants and if my office should be withdrawing from this case.
Well, what happened was I entered an order striking some pleadings back in November. There were some more pleadings that were filed. I struck those in last week. And then there were some more pleadings filed, and I have a motion.
This right here is the moment where the judge realizes traditional courtroom language is basically being replaced with sovereign citizen code phrases in real time. Special appearance, third-party intervener, artificial legal entity, overstand. These are all phrases commonly used in pseudo-legal circles where defendants attempt to separate themselves from their legal identity or challenge the authority of the court itself. But notice how the judge responds. He keeps pulling the conversation back to practical reality. What is your name? Do you understand the bond conditions? Have you hired a lawyer? Those are the legally relevant questions. And honestly, the judge's patience here is remarkable. A lot of judges would have escalated this much faster once the interruptions and jurisdiction challenges started piling up. Instead, he uses humor to diffuse tension while still making clear that bond violations could land the defendant right back in jail. The overstand exchange especially stands out because the judge immediately recognizes what's happening, an attempt to avoid traditional legal phrasing while still technically responding. But the court doesn't care about semantic games. What matters is whether the defendant comprehends the order. There's also something important happening beneath the humor here. The judge is building a crystal clear record. He repeatedly confirms the defendant understands the conditions of release. Why? Because if bond conditions get violated later, there's no argument that the instructions were unclear. Everything is now documented on the record. And that's why experienced judges stay calm in moments like this, because procedure matters more than emotion in court.
Citizen to the United States of American Republic, which is a sovereign government that has its own jurisdiction. Is the court aware of that?
Nir Brown. Good morning. Are you Nir Brown?
I'm not hearing here today. Special appearance.
I'm sorry. Speak up so I can hear
Here
you.
today.
You're appearing here today.
By special appearance.
Okay, what is your name?
I'm a third party intervener on behalf of artificial legal entity, not Nir Brown.
Okay. At one point in your,
And I'm talking about the chamber.
at some point in your life prior to being this third party, were you Nir Brown?
No,
You're not him.
I'm a third party intervener.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to, hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
That's relative.
So are you Nir Lewis Brown, or have you been him at some point in your life or not?
Yes.
Okay. So I'm going to call you by Mr. Brown because I'm not going to say all the words that you just said, because you've now identified yourself as Nir Lewis Brown. And so, Mr. Brown, this is your initial appearance, and you have two cases. And cause number 26, I just asked you not to speak over me. So here's the thing, Mr. Brown. I'm going to be very
I
patient.
had the child subject matter jurisdiction for on record.
Your challenge of the subject matter jurisdiction is overruled. Let me go through what I need to go through, okay? So this is your initial appearance, your first day in court. I'm required to go through what you're charged with by indictment. In cause number 26, DCCR 0322, you're charged with a third-degree felony offense of assault family violence by impeding breath or circulation from February 16th of 2026. And then in cause number 26, DCCR 0323, you're charged with the state jail felony offense of injury to a child, and that's from February 16th of 2026. And so since you have made bond and got out of jail on your cases, have you had an opportunity to try to hire a lawyer?
Is this what I'm saying?
Speak up so I can.
Up and down.
It's been up and down?
Yes.
Okay, so here's what I'm going to do, Mr. Brown, is I'm just like everyone else. I'm resetting your case about 30 days to give you some time to try to hire a lawyer. You need to try to get someone hired before the next court date. If you do, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? I'm sorry?
Overstand.
Say it
They
again.
overstand.
You overstand?
Yes.
Okay. What does that mean?
Overstand.
Do you understand what I'm saying, sir?
I'm blind.
You'll oblige.
I'm blind. Yeah.
Okay. You just determined to use different words and be difficult, aren't you?
No.
Okay. So as a condition of your bond, did you have a condition that you were not to have any contact or
This
communication?
hearing ended up becoming a masterclass in how courts deal with self-representation, sovereign citizen-style arguments, and defendants attempting to challenge jurisdiction through unconventional legal theories. Across all 3 courtroom exchanges, the judges consistently did the same thing. They redirected everything back to procedure, evidence, and courtroom rules. Gregory Smith tried attacking probable cause, bond conditions, and jurisdiction through constitutional arguments. Prince Pew attempted to file motions independently while still represented by counsel. And Nir Brown pushed identity-based and sovereignty arguments while resisting standard courtroom communication. But in every situation, the courts stayed focused on one core principle. Legal process does not disappear just because someone refuses to recognize it. What's especially interesting is how differently each judge handled the tension. One relied on calm explanations, another used strict procedural rulings, and another mixed humor with warnings to maintain control of the courtroom. But none of them accepted the idea that alternative wording, special appearances, or sovereignty claims automatically override criminal procedure or bond conditions. And that leaves the big question for viewers: do tactics like these genuinely help defendants? Or do they ultimately make their legal situations worse by distracting from actual defense strategies? Drop your thoughts in the comments, because these hearings always spark serious debate. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.